So let's just kick off. Okay, so this is a training, so everyone can be. We had a webinar in the late September. It's about Turkey-China debt collection, but unfortunately, because of some technical problems, one of speakers from the Turkey side were not able to join our webinar. So that meeting turned into a half webinar, meaning it's only a debt collection in China. But then we got a letter from our commercial counselor of the Embassy of Turkey in China. They showed very great interest in our webinar. So we proposed, why not we have a full one this time? We can have a full webinar on Turkey-China debt collection. And as a closed meeting, so it's not open to the public, just two speakers from both sides, from China, from Turkey, and me as an organizer, and with our four distinguished guests today. And later we'll welcome any questions, comments from our guests. Okay, so today our topic is about Turkey-China debt collection. I'm sure debt collection, the term itself is not unfamiliar for everyone, right? Especially for those legal professionals. They understand what legal debt collection is. But for most enterprises, most companies, what they understand debt collection is about getting my money back. And that is correct. That is what we do. We try to help all the enterprises, companies, individuals to get their money back. So normally getting money back is not that difficult, but it can be very tricky and hard when it comes to the cross-border debt collection, meaning to get your money back in another country. So this time we're going to talk about the cross-border debt collection in two countries, one in Turkey, the other is in China. So we have two guest speakers today, one from Emre law firm, the other from Tianyuan law firm. They are both top debt collection agents in the law firms in the world. We have our first speaker, Mr. Emre Aslan.
Yes, so, thank you very much for giving us a chance to introduce us.
Yeah, thank you very much. Do you have a slides to share with them, or are we just going to start to talk now?
I'm just going to start talking out by just introducing our company.
No problem.
Our office, Emre Law Office, is the first company who practices international cross-border debt collection in Turkey. Our first specialization is the international debt collection, and we are established in 2005 with the efforts of our founding partner Alper Kesiklioğlu, who is also in the managerial position with Duet Kesiklioğlu since 2008. Alper Kesiklioğlu has 25 years of experience in this field, especially in international debt collection and handling commercial matters such as banking and financial law or international commercial law. He also holds an LLM degree from the University of Maryland Law School since 2018. Our other partner, Duet Kesiklioğlu, who has several international experience with her practices in Oldenburg and Eindhoven. She also holds an LLM degree from the University of Florida, and they both are licensed trademark and patent attorneys registered with the Istanbul Bar Association. We have three offices for now. Our main office is in Istanbul, Turkey. And we also have two offices. One is in Eindhoven, Netherlands, and one is in Washington, D.C., United States. Our branch in US, Washington, D.C. also works in the area of immigration law, while handling numerous cases such as asylum applications, labor certification process, immigrant and non-immigrant visa issuances, which is very important if you have an office in US. All of our offices, with the geopolitical position of the countries which they are located, have a key importance and value in resolving issues regarding any relations between China and the rest of the world. If you take a look at it, our office in US serves kind of like a bridge between China and US about any commercial matters. Our office in Eindhoven gives Chinese companies a better chance to have a partner at the center, at the heart of the Europe. And our main office in Turkey, Istanbul, may serve in favor of Chinese companies' commercial purposes, since Turkey has unlimited potential regarding its geopolitical location. All of our offices are capable to handle any kind of workload with its more than 50 staff. We give debt collection and legal consultation services with our solution partners also, which is encompassed in more than 130 countries, which makes us act as fast as we can regarding any matter. We also trace with approximately $40 million of risk, trace receivable with that kind of amount. And we are proud to give those services to numerous financial institutions around the world, along with several banks, insurance companies, and international corporations. To introduce and give an entrance to this talk, that's what I could say about our company also. And if you just like, I could get into the amicable collection process just as fast as I can.
Okay.
As you know, the debt collection in general have two parts: the amicable collection part and the legal collection part. The amicable collection part is the part that we try to collect the receivable amount within the amicable ways. We are getting contact with the debtor directly. But first of all, I have to mention that it is important that non-lawyers cannot practice this area law. It is forbidden by the law for someone who does not have an attorney license to make legal debt collection in Turkey. So you have to know who you got in contact regarding this collection matter first. If you don't have any partnership with someone who doesn't have an attorney license, your collection efforts may be in danger. So in order to get adequate and legal valid service, it is crucial to work with the right person. And as you may know, to start the debt collection process within both amicable and legal ways, the best service starts with some efficient investigation regarding the debtor's current status, their financial status, if they have any debts, if they have any assets, or
no questions at this stage. Please go ahead. Thank you.
Okay, thank you very much.
Okay.
Thank you very much. So about the investigations, clients in general tend to decide their action after learning about the debtor's financial status. That's why our all in-house investigation team performs the best investigation reports possible, including external traces, site visits, and credit reports in order to satisfy the client. After getting the relevant documents from the client, we try to find the contact information as soon as we can, so we can get in touch with the debtor directly. After finding out the contact information, our calling team makes the calls as fast as they can. They try to reach the debtor in any ways. They send mails, they send messages, they call them. We perform site visits also in order to see the debtor and have a conversation with them face to face for full client satisfaction. And by the way, in this collection process, we work with the incasso system. As you may know, incasso system is more in practice all around Europe. Is a system which the debt collector tries to collect within the amicable ways and does not request any kind of payment from the client unless any kind of collection is made, partial or fully. It doesn't matter about that. So it's basically no cure, no pay. That's the base way for the amicable collection process. That's how we work for years, since we got established in 2005. Antroya has the trademark rights of incasso in Turkey also. So no one in Turkey could use any rights of this without asking us. The amicable process is basically like this. You try to collect as much as you can by getting in contact with the debtor. And if there is no chance to make any collection and the debtor is not tend to pay any kind of payment, we suggest to go to the legal in that case, which is like the last resort in order to get collection for us. We deem this at the last resort. There are two options to pressure the debtor with legal ways. The first option is to send an official payment order to the debtor's official address and start the first instance with the enforcement offices in Turkey. This shall give the debtor 7 days to object by law. After getting the official order, debtor has 7 days to object. If they can't, we can start seizing their assets and getting confirmation from the client to sell their goods in order to get collection. If they object in that time being, we have to annul that objection by submitting the case to the court. This court process may take up to a year with this mediation process and any other necessary proceedings that need to be done. But after the annulation, as I said, we can continue with the standard procedure, start seizing the assets of the debtor and getting confirmation of the client for the sale. As the second option, it is available if the client has a title judgment in favor of them. It's the recognition and enforcement process. We can start the recognition and enforcement procedure before the court and request a judgment to be deemed as enforceable, just like a Turkish court order. After the court process, we will be able to enforce the judgment and debtor shall have no right to object, since there's just like a Turkish court order. If the client has a title judgment but does not want to go with that option, we can use also that title judgment as a proof of debt in the first option that I mentioned. So in the legal ways, we have two options. Both of those may take up to 1 or 1.5 years. But as I said, we prefer to make the amicable collection as soon as possible, rather than going to the legal stage. In that legal stage, we also, I want to mention some problems we have with China. First of all, we get some problems about getting the POAs and apostilles. Since we have a lot of clients in China, such as some banks and financial institutions, we try to get into the legal stage as fast as possible when we suggest to the client. We request the relevant documents about it and request the POA, and it needs to be apostilled. But it takes a lot of time to get an apostilled POA from China. Therefore, we cannot start the legal process as fast as we can. And the second one is about this payments of collections. When we get a payment from the debtor, both legally or amicably, it doesn't matter about that. We have a problem to transfer that payments to China or getting any payments, any kind of fees or expenses from China to our Turkish accounts. Our intel told us about the situation that China in general took the Turkey as a forbidden country about those, and tries to get inspections as much as they can, taken as long as they can, and trying to inspect the payments from China to Turkey. Therefore, they have a lot of problems about sending us their payments. Those are the most problematic things that we have to face about debt collections between China and Turkey. About the office in our US, we also try to make immigration cases and debt collections in US by getting numerous cases from our partners and solution partners all around the world. We started that kind of business in the last 6 months, but we think we are confident about it, and we can serve our clients with full satisfaction in this matter. In fact, we also exceeded 1,000 cases in that office, and we think we can continue about it for a long time. What can I say about it is also the legal procedure is done, and I think that's all for what I can do.
Thank you. Is that all? Thank you. Thank you for your sharing. Thank you very much, Mr. Emre. You talked about the two different types of debt collection in Turkey. One is amicable debt collection and the legal debt collection. And very interestingly, you raised some challenges now between the China and Turkey debt collections. You mentioned about the POA, power of attorney, and apostille. In China, we call them legalization. I assume we're talking about the same thing. That is, once a Chinese client needs to sign on a POA, and then they need to be legalized by the consular or embassy here.
Yes.
That is correct, right? So later probably we can have some discussion on this part. And another challenge you just mentioned about the payment of the collection. This always a little bit tricky. It'll take a much longer time than expected. That's actually happens.
Yes.
We have encountered kind of problems like this. There's one particular reason I think you are familiar with that. That's a forex control. There's a forex control policy in China, and it really depends on the country where the payment is going, right? Say we have payment coming from the UAE, we have clients in UAE that they start to pay us, but then it takes us about 2 or 3 weeks to go back and forth with the bank here, because we need to prepare much more documents than normal. They will review every document, ask questions, we submit some additional documents, and then to help them understand better about this genuine deal. So it's not a fake deal, it's not about laundry, okay, money laundry. And then the bank can say, okay, we are assured this is the genuine deal, and then things can go very smooth after that. So yeah, it can be very lengthy sometimes, but it's because of the current policy here. So we do understand the challenge, and I expect more discussion on this matter as well. Okay, thank you very much.
You're welcome.
Now let's thank you. And now let's move on to Mr. Chen Yanzhang, partner of Tianyuan Law Firm. It's a top law firm headquartered in Beijing, China. Mr. Chen Yanzhang, you may start whenever you are ready. You can also introduce your firm and your personal experience to start with. Thank you.
Thank you, Dr. Could you please open my power to share my slides? Because I think,
sure.
Yes.
I think you can.
Okay.
You
Sorry,
can try.
I'm still not allowed to share my
Okay.
slides.
Okay, let me try all the settings here. Just hold on for a sec. How about now?
Oh, I have become the host.
Yeah, I know. That's the only way I think it might work. You can be the host at this stage, okay? And then I'll take my host back.
Okay, got it. Well, thanks to Emre and thanks to our distinguished Chief Counselor, Mr. Hakan, and all other 3 counselors. Please allow me to express my gratitude to your attendance in our webinar. And just like Dr. Yu said, we just had a half webinar late September, and on that day, I just tried to introduce many parts of debt collection in China. But today, I would like to be brief and to leave more space and time for our communication or interaction between each other. And as to our law firm Tianyuan, this is a quite aged law firm in China. It was established in 1992, the first batches of law firms established in China. And now we have about 700 employees, including lawyers, also partners and other supporting staff, about 700. And we have about 12 or 13 offices across China, including Hong Kong. But now we still do not have overseas branches, but in the future, maybe we will try to expand that. As for cross-border issues, Tianyuan, we just have very close communication and interaction with Dr. Yu, the CJO Global, the organizer of today's webinar, and including the business enterprises, business entities, you do consulting and try to expand our overseas networks. As for myself, now I'm a practitioner focusing on dispute resolution in China for over 10 years. And for trademark and international trade and other cross-border debt collection is my area of specialization. As to the commercial background investigation mentioned by Emre, that is also an area of Chinese lawyers, including me. And in addition to all of these, we also assist our clients in overseas judicial assistance, which means that we help them to handle matters related to services of court documents from overseas courts. And we try to help them to go abroad, to go to other countries to seek clues of their debtors and try to collect debts to help our Chinese clients. So we do cross-border issues from both go abroad and also come to China. So that is a very brief introduction of myself, and I will not spend too much time on this. So let's just come back to our topic today, that is how to collect your debt in China in very brief ways. So first, I would like to introduce some very, very general principles of collecting debts in China. The first is about what debts can be collected in China and what are typical debts to be collected in China. Well, in one word, all legitimate debts can be collected in China. And the most typical ones I understand includes the payments of goods under international trade, the trademark licensing fees, and loans. So these are most typical debts to be collected in China. And I think the payment under international trade shall be the most common one between China and Turkey. That is my understanding. Maybe that is wrong, but I understand Mr. Hakan or other counselors can give more introduction or direction on this area. And there are four basic principles to do debt collection before your start. The first is that you need to understand and make sure who is the debtor. Well, actually, that seems is not a question in most cases, but actually that is the most important one before you start, because your Chinese exporters, they may trade with you with different names. They may contact you in name of an individual and later sign contract with you in name of a company. And then they send or deliver their goods to you in another name of company. So who is the debtor? That is the most important question, because when you start your action, either amicably or in legal ways, you need to target one. You need to send a letter to one specific person who should be the addressee. So that is the first question. And second, you need to show to your debtor that we are serious and we can reach you. In most cases, I think Chinese exporters, they just keep silent and they escape from communicating with you if they find you need to seek debt collection with them. But if you can show that we have a local lawyer, a Chinese lawyer, we can find you and we can know your contact information. We can call you, recording the communication between each other. They will get very, very serious about this and try to talk with you to find a solution. So the second principle is to show that we can reach you and we are serious. And the third one and the fourth one, I think that is some very quite general and easy to understand principles. That is to know the credit and property of the debtor and make a comprehensive plan. Because if the debtor actually has no properties, even you win the case, that is not meaningful for you. You still cannot recover your property. And the fourth one is that I think the best option is to make sure that every step is planned before you start. First, what should I do? I need to know the debtor. I need to make plan about specific steps to do all my actions. So here, let's come to some specific plans, steps, or methods about debt collection in China. Well, I understand the first step to collect your debt in China is to send an attorney's letter and oral notice to your debtor. That is somehow similar to Mr. Emre's introduction before in called amicable way. But I understand attorney's letter is not that amicable or friendly. It's a legal step to start debt collection. Why do I say so? Because I understand it is a good way to show we can reach you. And it is a method to collect evidence. What does that mean? That means, well, by sending attorney's letter and get the answer from the opposing party, that is a good way to make sure who is the debtor. Well, actually, in some cases, we are not sure about the debtor at the beginning, and we try to send a letter to one that we propose to be the debtor. And then we talk to them in telephone or get their feedback by WeChat or some other social media ways. And they admit that, yes, I'm the debtor. So by sending attorney's letter and give oral notice and later communication, that is a good method to collect evidence about who is the debtor, or even they admit that, yes, I owe you how much money. After sending letter, giving oral notice, and have friendly or say amicable communication, if all these efforts fail, so let's come to some ways in force or legal ways. The most common way is to initiate a litigation case in China. And this picture is a picture of the Supreme People's Court, the building of the Supreme People's Court, and the logo of Chinese courts. Well, let's just give a very, very brief framework about litigation in China. Well, China has a 4-level court system with over 3,500 courts all around China. That is an unofficial data I compiled. There's one Supreme People's Court and 32 high courts in China in different provinces, and over 400 intermediate courts located in, we say somehow, big cities in China, and over 3,000 primary or basic courts in different districts or counties in China. And most litigation cases in China are filed in the lowest 2 levels courts, the intermediate courts and primary courts. And most cases are closed within 2 instances. So that means you need to go to 2 courts at most to close your case. About the jurisdiction, well, that is the court at the defendant's residence has the jurisdiction over most cases. That is the most common connecting factor to file your case. As to the general process, I will not spend much time here to go through that. That is somehow very similar to most court procedures across the world. But one thing to point is that, well, in China, the document evidence or documentary evidence is the king of evidence. As to the witness of the statement of witness or cross-examination, they do not play a very big role in China's court proceeding. So that is one point I would like to share. Another thing we would like to focus or emphasize is that you can try to seek property preservation measures in China. What does that mean? Well, this picture is to show that the court in China, the court clerks, the judges, they can go to the location of where the defendant's property locates and try to seal up, seize, or sequester the property before a legal judgment is rendered. So property preservation is the measure to freeze the defendant's property before the judgment is rendered. That is a very, very important way to avoid the defendants from transferring or concealing their property. When they know that you are trying to seek debts, you are trying to collect debts from them. And here, the preservation measures can be conducted online, and we will introduce that very, very soon later. But here, you need to provide clues of property. Without clues of property, the courts will not try to help you at this stage. And last one, you need to provide guarantee for example, a bond from insurance company or bank, saying that if the measures is taken wrongly and I make some losses to the debtor, the insurance company or the bank will compensate the debtor. As to court fees, it is collected by the courts in progressive rates, and I just list a very simple here a catalog about the fees of different claim amounts. Well, to say in one word, I understand the average fee rate for Chinese court. If the claim amount is not that too high or too low, I understand it is about 1% of the amount you claim against the debtor. So in addition to litigation, arbitration is also a very common way to collect debt in China. But if you want to seek remedies from arbitration, you need to have an arbitration agreement or arbitration clause in your contract. That is a quite simple understanding and easy to understand. As to the difference between arbitration and litigation in China, I understand arbitration has lower requirements on formality documents and evidence. Just like Emre said and Dr. Yu, you communicate about the formality of legalization from embassies or other consulars, foreign affairs departments of some POAs. I understand arbitration in China, they do not require a legalization of your formality documents. That is one difference between arbitration and litigation in China. And the process of arbitration is somehow similar to litigation, but more flexible. And still, property preservation can be applied, is available in arbitration proceeding. And the last point, we need to mention that there's no appeal in arbitration in China. And the word, once it is rendered, it is very, very hard to be set aside or revoked. So you need to pay all your attention in the only proceeding of arbitration and make sure you make all your effort to win the case. Here, the fourth one is about settlement and mediation. Well, here, the settlement and mediation, it seems conducted amicably, but actually here, we talk about these measures after you initiate litigation or arbitration, or in the preparation of such proceedings. Here, settlement means that you try to negotiate with the opposing party without the help or support from court or arbitration institutions. And mediation here means that you have judges or arbitrators to organize a procedure or help you to communicate with each other to reach a settlement agreement or something else. Such procedures, we mentioned, it can be conducted before, during, even after litigation and arbitration. Well, here, what does after litigation and arbitration means here? Well, in the following slides, we will talk about enforcement, which means that the court compelling the losing party to perform the judgment or the arbitral award. But in the procedure of enforcement, the parties, they still, sorry. Yeah, they still can reach a settlement agreement or they can do mediation here. And such two measures, speaking frankly, they are truly, truly welcomed by judges and arbitrators. And we even say they are the love of judges and arbitrators, because if settlement and mediation succeeds, the judges and arbitrators can save much, much time about writing judgments or arbitral awards. And the result is recognized by each party. So that is a very safe and friendly way to resolve your dispute. But last point, you need to pay attention to the enforceability of settlement and mediation, because if you reach settlement agreement privately without the help and support of court or arbitral institution, the agreement cannot be directly enforced by courts. You need to go to courts to make the settlement agreement recognized by courts, and then the documents can be enforced. So actually, in most cases, we will recommend our clients to reach settlement agreement with the help of court and arbitral agreements and arbitral institutions, and get a document from them. So in case the opposing party failed to perform the settlement agreement, you can just go to court to make it enforced. Here, we finally come to enforcement, a very, very important procedure in China, because in many cases, the losing party of a case, they will not perform the judgment or the document from courts or arbitral institution very voluntarily. They will not do that. So you need to seek the court to enforce the deed, the document, and using the power of the country. This picture is a scenario of Chinese judges, court clerks, and police from the courts. They go to the location of the enforcee, or say the losing party, the defendant, to try to seal up their property, to find properties of the losing party. Here, enforcement is the power and the duty of the court only, which means that the parties, the plaintiff or the applicant of arbitration, you cannot enforce the property of the losing party privately. You need to seek help from the courts. And the methods of enforcement here generally include tracking down and freezing the property of the losing party, and organize an auction on the property that has been frozen. And then the court will do the liquidation procedure, which means that they will return the money get from auction to you. As to the remaining part, they will pay to the losing party to return that. And here are some very interesting methods. The third one and the fourth one is that Chinese courts, they can restrict the losing party on unnecessary consumption and some other acts. For example, if you want to travel by air or high-speed train, you will be restricted if you fail to perform the court judgment. And for some very serious acts, the court can even conduct criminal punishments on the losing party. There's one concept in China, we say dishonest debtor. And if you are ascertained as the dishonest losing debtor in China, you will suffer very, very serious restriction, even criminal punishments. And the last point we would like to share about enforcement is that how can Chinese courts conduct so many actions or so many efforts to help you to recover the debt? They have very limited court staff for enforcement. So how can they achieve that? Well, they just do that with a great help from the online system of enforcement. What is that? Well, the online enforcement system is a network information that connect the computers in the courts with computers of different entities. Let's say administrative organs, air companies, and even other entities which needs to support the court's enforcement. And the judges, they can just click their mouses in offices, and they can see almost all the properties or the clues of properties of the losing party. If the property is subject to registration, and the registration entity has connect their network to court, the judges, they can find that. And most entities or administrative organs, they have connect their network or information system with the court. So here, thanks to the very, very mature and powerful online system of enforcement, well, I think as of 4 years ago, Chinese courts have already frozen a total of RMB near 300 billion RMB yuan of properties of the losing party. And they have conducted more than 747,000 online auctions with a turnover of about over 500 billion RMB yuan. They have recovered over such amount of property and returned the money back to the creditor. And Chinese courts have already restricted near 20 million person times to travel by air or high-speed train. And if you cannot go travel by high-speed train, actually that is very, very difficult to do many things in China, I understand. So that is a very brief about try to be full-scale introduction about enforcement in China. So I would like just to convey a concept that enforcement in China is very, very powerful today. And the last page is about recognition of foreign arbitral awards and judgments. About recognition of foreign arbitral awards, that is quite a mature concept and practice in China, which is based on the New York Convention. And the Supreme People's Court of China, they have very strong support in this aspect by establishing a system called internal reporting, which means that if local courts, they would like to refuse to recognize a foreign arbitral awards, they need to support the case to the Supreme People's Court to make the final decision. So as the result, the cases of recognition foreign arbitral awards are seldom dismissed. And the last point is that in these cases, you also can seek property preservation before the decision of court is made. So just remember, seek property preservation whenever you can. That is quite important to recover your debt. About recognition of foreign judgments, such cases are comparatively speaking much more rare compared with the cases of foreign arbitral awards. As between China and Turkey, we have treaties about recognition of the judgments of each other. And there used to be one case in Shandong province where the judgment of Turkey was recognized by Chinese court. But comparatively speaking, the number is still relatively rare. But after 2022, this year, China has adopted a much more friendly attitude. And we cannot expand this practice today too much. But in one word, China is much, much more friendly by lowering the requirements of recognizing a foreign judgment. And still here, property preservation is still available. I would like just to, in Chinese words, we say that for important things, you need to repeat that for 3 times. I think I have repeated this point for over 3 times. So I hope that is helpful for Mr. Emre, for your clients, and Mr. Hakan for our Turkey friends. Yeah, just remember, property preservation in China is truly important. So that's all for my for today for my topic today. And here's my email. And if you have any questions, I'm more than happy to talk about that today and even after today's webinar. So Dr. Yu, I would just like to transfer my power of host to you back. Okay?
Okay, no problem. Thank you. Very, very much, Chen Yang. You did give us a very comprehensive introduction about at least the framework, the landscape of debt collection in China. You talked about attorney's letter, which is very similar to the amicable debt collection in Turkey. And there's litigation, there's arbitration, everyone familiar with that. And then you move on to talk about the useful, very useful settlement and mediation. Like in China, everyone knows that's the love of judges. Apart from the one that you mentioned, because they are cost effective, time saving. I just want to add a little bit on that. Is it true that if the judges who can conclude the case with a higher rate of mediation, they will have a higher score in the final assessment for themselves? So that's kind of related to that as well, right? And you mentioned about the powerful enforcement system in China as well. This dishonest data and a high consumption restrictions measures. That's something very special in China. We got a lot of clients coming to us to ask us, what is this dishonest data thing? So we try to explain them as well, because think about that. If you become a dishonest data, which is registered in Chinese national list, right, you will suffer high consumption restrictions. You can no longer to go on the train, a high-speed train. So that's definitely a big problem for them, at least for the company managers. And then you move on to and conclude your presentation with the enforcement, particularly on the enforcement of arbitral awards and foreign judgments in China, with a very positive trend. Hopefully, we could have more time to share everything about debt collection in China, probably next time. But now let's have some time for the Q&A. Okay, this is our Q&A session. Would like to our four distinguished guests, if you have any questions or comments, please feel free to ask and share. Or you can comment on our two speakers' presentations.
I understand the one case we just mentioned. I think the judgment was rendered by the sixth commercial court of Istanbul, according to some news and a report from the courts in China. And the judgment was finally recognized by a court in Jining, city of Shandong province. As to some more specific details of the case, I think it is not public and open to us, but for the requirements you mentioned to recognize of a Turkey court judgment here, based on the development I mentioned this year, Chinese court, they lowered the requirements, and the first criteria is to follow the treaty between Turkey and China. It has many details about how to recognize a Turkey court judgment in China. Generally speaking, Chinese courts, they need to ascertain that the Turkey court, they has the jurisdiction on the case, and the proceeding adopted by the Turkey court has already protected the interest of the Chinese parties. For example, they have tried the Turkey court has tried the best to subpoena Chinese court and to respond or answer the claim of Turkey party, and they have noticed Chinese party about their rights, legitimate rights to in procedures of Turkey court and some other such kind of requirements. And the judgment does not, let's say, violate the public interest of China, especially some basic system, political system, or some other public interest of China. And the judgment has no part about, let's say, punishment damages that very much that exceeds the actual losses of the party too much. Has no parts of this kind of expressions. So that is a very vague or just, let's say, framework, such introduction is just in framework. And if you have interest in some more specific requirements, I would like to prepare detailed PPT or some other documents for you on this measure that is specially targeted for Turkey parties. We actually have webinars about this topic in general ways. For example, we talk about a recognition of German judgment in China and other countries. And if you are interested in, we can just prepare one about Turkey. Yes.
Thank you very much, Mr. Zhang, and thank you very much, Mr. Adnan, for your questions. If I may add, I just want to add a few words on your question on whether Turkish judgments can be enforced in China. The answer is yes, definitely yes, because luckily we have the bilateral agreement between China and Turkey on judicial assistance. That bilateral agreement was concluded in 1992. So China has concluded with a couple of countries on this judicial assistance matters. Okay, only a total of 33 countries have this bilateral agreements, and Turkey is one of them. Many other major trading partners like United States, the United Kingdom, the Germany, Australia, Singapore, they don't have such bilateral agreements. So it will be much harder for their judgments to get enforced in China. So for Turkish judgments, it's already much easier compared to judgments from other countries. As for the requirements, Chen Yang just mentioned, so Chinese courts normally would not go review any substantive matters in the Turkish judgments. They were not going to say, hey, that's wrong, you didn't rule it in the right way, the facts are wrong, the laws are wrong. No, they were not going to that kind of details. All they're going to check are just some procedure matters. Say, okay, whether Turkish court has jurisdiction or whether the Chinese defendant or Chinese judgment debtors' procedural rights was guaranteed in that Turkish court proceedings. They are only going to look into those procedure matters, just trying to ensure the due process and the human rights, the procedural rights of the judgment debtors. Okay, so it can be, let's say, very feasible, very feasible for us to apply for the Chinese court to enforce a Turkish judgment. And as for our company, Yudo Company, CGO Global is a brand under our company, and we're proud to provide this service as well. It is actually our 5-star services. It's called Enforcement Foreign Judgments. We have country guide, actually. We have country guide. Say, there's lots of country guides for judgments rendered in different countries. How are you going to enforce the judgment from your country in China? We have a whole country guide for each jurisdictions. So then the Turkish one is coming about actually next week. We're preparing that. So like Chen Yang mentioned, Chen Yang's going to prepare some documents on this. We're going to also send you the country guide on this matter as well.
Well, like you said, it depends on the difficulty of the case. And if we find that the case is truly difficult to go to the court or get a judgment, we will advise the client to try best to seek settlement or mediation. And here our fees will have a quite, let's say, discount or something else, right? So everything we need to check with the specific cases first about the plot line or the circumstances of the case. And I understand, Mr. Uger, you would like to get a somehow standard or guideline of collecting fees about Chinese lawyer. Well, actually, for the amount I mentioned, $50,000 US. I understand for easy cases, the basic fee here, we will first collect about, I understand, 30 to 40. 3 to 4 thousand US as the basic fee of going to courts, and then we look to the result of the case. But if the case is finally settled by settlement or mediation, we can give a discount on the basic fee, and later for the contingency fee, we will collect that after the money is returned back to our creditor in Turkey. Here, first, we would like to say, if the company has only one shareholder, well, generally speaking, the shareholder has the right to prove that his or her asset is separated from the asset of company. Otherwise, the shareholder needs to be liable for the debt of the company. So that is the first principle we mentioned about one shareholder company. And most very many companies in China, especially trade companies, they are one person or one shareholder company. So we will truly advise our clients to seek debts against both the company and the only shareholder. So that is the first principle. If the company has more than one shareholders, and the shareholders, they did not distribute or devote their assets to the company, you need to first read the articles of association of such company, because Chinese law, they allow shareholders to distribute their assets or capitals to the company later, even 20 years later. Chinese law allow that. So if the articles of association, they set the timeline in a very late ways, it is difficult for you to seek remedies against the shareholder. In the first step, you need to sue the company first and try to enforce the judgment. And the court, they may just return you a result or feedback that, sorry, the company has no assets, we cannot enforce them. Then after this stage, you can again apply to the court to add the shareholder into the enforcee, the person to be enforced. So there's two steps for, we say, adding or just further claiming against shareholders. You need to have some pre-procedures before you claim against them. So that is more complex with the one shareholder company. So let's come back to your first question, Mr. Uga. You mentioned about how we collect fees, right? It depends on the complexity of specific cases. So about claiming against shareholder, you need to just distinguish one shareholder company and other companies. And there are more complex principles or rules in practice. We would like to introduce you in a later webinar or something else, okay?
First decision time differs by the options. As I mentioned, there are two options for this. The first one is the first instance, where we send a demand letter and an official payment order to debtor. In that case, if debtor objects, we have to annul that objection in order to continue to the process. In that case, most of the annulment processes may take up to a year and maybe more than a year. Depends on how fast we can take action. That's important. That's where the importance comes in between the relationship between our clients in China and our personnel. So, but in most of the cases, it may take up to a year since there are some necessary regulations. As soon as there are some B2B cases that needed to be initiated by some mediation procedure or some arbitration procedure that deemed by the law. That may take up to a couple of months, but in general, the conflict is not resolved in these situations, in mediations or arbitration. So we take that mediation order that we couldn't we couldn't make a settlement in regards to the mediation process. Therefore, we submit our documents to the court. And in that case, since the workload is literally unbearable that the Turkish courts have, unfortunately, the process may take a long time, maybe more than a year, as I said. But as I mentioned before, the legal procedure is the last resort for us. This is for the first option. The second option is where the Chinese company has the title judgment, the recognition and enforcement process. This is, in general speaking, is a simply procedural thing. As Ms. Yu mentioned before, as is done in China, it's just simply procedural. The court takes a look at if the title judgment in China is enforceable in accordance with the laws of Turkish private law. But the most common objection in those cases is about misrepresentation. In most of those cases, debtors object to the title judgment as we couldn't have the chance to raise our objections. We couldn't have the raise our comments in the court of China. They didn't give us this chance, so we have to raise our objections in Turkey also. In that case, the court may order that we have to get into the context of that case rather than just evaluating if it is procedurally available to get recognition enforcement. Unfortunately, if the court orders like that, it may take up to 1.5 years to conclude the recognition process.
Okay, Thank you.
You're welcome.
Thank you, Emre Aslan. Thank you very much for your questions, Mr. Carroll. I also would like to raise one more question here for two speakers. As Mr. Hakan mentioned that in recent months, or let's say recent years, very typical disputes have arisen, right? That is related to the quality and the quantity of the goods. How are we going to deal with this? We have been receiving lots of complaints from overseas clients as well. They come into us, always the same thing. Chinese exporter says they have shipped 10 tons of steel, but then in the end, only 5 or 6 tons. That's just so typical. I'm not saying all Chinese exporters are dishonest. I'm not saying that, but this type of dispute are really, really typical. So as I understand, we have some agencies like SGS, that's an international well-known inspection company. So we have daily cooperation with them as well. So we have kind of a specialized agencies like them, right? We also have law firms, very, very top law firms, specialized law firm like your two firms. How do you think it would be possible for us or all the legal professionals to help these companies to deal with this type of disputes? Because you see, when the Turkish clients companies, when they received all the goods, when they find something wrong in the quality or quantity, it happens already in Turkey. It's not in China. And Chinese exporters, they would deny that. Okay, how would you say, what are the possible ways for us to resolve these problems, or better, to prevent this kind of problems from happening from your legal perspective? Thank you.
Well, as I said, the amicable solution is the best way for us to make the collection. So before going to the legal procedure, it's best to get in contact with the debtor directly, most of the representatives, the CEOs, the sales departments, etc., and to make a settlement. But as you said, in most of those cases, we have some problems about the financing issues for those exporting and importing companies. For example, in a scenario, a Chinese company exports to Turkey, to a Turkish company. The Turkish company wants to make the payment, but they have some financing issues, and Chinese company sells the products to another third party. And in that case, especially in export insurance things, the risk ratio is still on the creditor. They sent the case to some exim banks such as Signature, etc., and they try to make collection with that case. In those instances, most of the Turkish companies object that we couldn't even get the goods, and the goods is not what we thought, what we negotiated within the agreement. As you may take a look at the SGS reports, the inspection reports, etc. Yeah. That's the most common thing we face in these issues. We usually solve those kind of things with amicable solutions without going legal, because in most of those legal cases, especially in the B2B ones, the commercial records of those both companies are important for that, and most of the court orders do not give order in favor of our client, since the commercial record sees that the Turkish debtor did not get the goods. We object this, we bring this matter to the Supreme Court, but it takes time. So in the legal procedure, it is actually frustrating. It's not because we are wrong or we are right, it's because it's frustrating and the client wants to avoid this procedure, and therefore we want to make the collection in an amicable way as well.
That's absolutely very true. Compared to very frustrating legal proceedings, amicable debt collection is definitely much more preferred way for most companies in such scenario. What would be the case in China then, Chen Yang?
Well, generally speaking, I fully agree with Mr. Emre. If amicable resolution, this method fails, if you need to go to court, well, generally the inspection result is truly important. And whether the party, they have agreement on how should we conduct inspection, where we should we conduct inspection, and when, how, that is very important. And if you fail to agree on such clauses, and if you need to go to court in China, let's say, well, generally, I think Chinese courts, it's very difficult for them to determine how should we set the standard of inspection. And we would like here, if the client, they insist on trying, we would like to advise them that you can just submit, say, the report of SGS or CCIC in China.
Yeah.
What do you have? You just give to us, and we will submit to the court and try to convince or persuade the court that this inspection is the best way we can do in that scenario, and try to convince the court. So here, we would also like to advise all our clients, exporters, you need to make agreement about inspection, very, very important, either in China or in Turkey or somewhere else. You need to have an agreement and follow such agreement. That will be very helpful to protect your right before Chinese courts. Yes.
Thank you. You also mentioned a very preventive way, right, to prevent this issue from happening. That is to add who will bear the cost of inspection in your contract. That's very useful.
Yeah, but how should we conduct that? Yeah.
And how should we conduct that? Yeah. But then in the end, we found out for many companies, especially SME, small and medium companies, they actually don't have any agreements. That's the reality, right? They only have invoices, orders. They don't have agreements at all. They only have emails, or sometimes even not emails, email to start and then end up with WeChat, WhatsApp messages. That's their contract. So we need to work on more on this kind of issues. Okay, I think we are kind of running out of time. Originally was scheduled for 1 hour. Now it's already 1 hour and 23 minutes. I don't know whether we have more questions or comments would like to share with everyone here. Anyone? Would you like to go? Or if no, I think we had a very fruitful discussion on this very topic. Thank you very much.
Thank you
Have
all.
a lovely day.